Welcome to Legal Beagle.
Welcome to Legal Beagle with Kristina Lyke and Zofia Morales. Today we are diving into what you really need to know about personal protection orders in Michigan. Attorney Kristina Lyke is here to break down what the law says and what a protective order can and can't do. If you're feeling unsafe, this episode is for you. Welcome, Kristina. I'm so happy to have you back with us.
Well, thank you. I'm happy to be here.
So let's start with the basics. What is a personal protection order?
So just basically what the title is, a personal protection order is an order that actually protects an individual. It's actually filed right here, in the circuit court of one of the counties right in the state of Michigan. And that's basically what a personal protection order is. There's two different personal protection orders. There's one that's called a domestic personal protection order, and the second one is a non-domestic personal protection order. The non-domestic personal protection order is actually one that you have to have two or more incidences that actually has happened or occurred to an individual, and that will cause that basically it's irreparable harm will happen if this order does not get into place, which is the personal protection order. The second form is actually the domestic, and the domestic is family members who live with you, significant others. It could be actually a roommate too as well. So they call that domestic as well.
Interesting. So why would someone want to obtain a personal protective order?
A lot of people want to obtain a personal protection order if they feel like they're being threatened, harmed. They might have gotten into a physical altercation with somebody because somebody was an aggressor. There are other incidences like on Facebook. We see a lot of social media examples. We see that people go and try to actually intimidate and harass people on Facebook, social media, on X. And although that they try to limit some of that, there's personal protection orders that protect them. Now, remember though, we have to have two or more instances if we're going to try to do a non-domestic personal protection order. So basically, it's to protect the individual, and I always recommend that an individual take that personal protection order as soon as you receive it and take it to your local sheriff or your local police department, and always carry one with you at all time periods. So that way, if you're in the mall or you're at Walmart or somewhere else, if the aggressor comes in, or the respondent, we call them, then you have that personal protection order on you, so it can show that they're not supposed to be around you.
Okay. And is a simple photocopy enough, or does it need to be like an official sort of?
No, actually, that's a great question. I actually state copies should be, just made. You can, and if I do it for my client, I actually have copies prepared for them so that they can have one in their purse, one in their wallet if they're a man, maybe one in their glove compartment, just so that they can actually have a few copies on hand.
Okay. And how do we go about getting one of these personal protection orders if we're feeling threatened in some way?
Well, just not threatened either. There's got to be like this, that you feel like you're going to be harmed, that someone's going to actually do something to physically injure you or harm or maim you. And those are what we look for. But as to getting a personal protection order, you can file one at the circuit court. And in the state of Michigan, you can file one in any county, which can be dangerous because you could live in Ann Arbor and receive one up in Kalamazoo County, right? So, and you might not know if one actually was placed on you. So what happens is you go to the circuit court, you file it. There's a legal advocate there that actually can help you file it. But I do suggest that if you do have the money, because you can do this on your own, come see an attorney like myself. I've been called the personal protection order queen lately for defending them, but I can check it over, review it to make sure. But I always like it in your handwriting, because when a judge looks at it, they want to see what your feelings are, and if you're scared and intimidated of this individual, and that gives them the showing and feeling that this order needs to be in place, but there's irreparable harm that's going to be caused to this individual. So therefore, it helps to have it in your own handwriting. Mm-hmm. And then once you receive the order, again, it goes right into lien. So the sheriff's department receives it, but you have to realize that human beings, they place that into the computer. So I always tell people, hey, just make sure that you have a copy, take it down to your local department of the sheriff's department. They'd be more than happy to keep one for you on hand, so that therefore you're more protected.
Can you give us some examples of of the harm that you've referred to a few times?
Sure. It would be like for example, a physical altercation, maybe a physical domestic abuse. We see a lot of times with significant others. We see roommates, they get into a fight about, it could be something little about like their iPad or their computer, who had it last. And sometimes during exams, we see it with a lot of college students that they're just intimidating each other because they're under anxiety a lot because of their exams. We also see things like a lot of it, I see a lot more lately with social media. You can see it with neighbors too as well, because neighbors want to try to, you have great neighbors sometimes, but some neighbors, they want to try to harass or intimidate because of a zoning issue, or there's like a dog barking. So, they're waking the person up that works midnights. They're all rational reasons if you think about them sometimes. But when you go and use fear tactics or threatening behavior, or you go over with your gun holstered in your side there, and you're ready to fight with your fist up, and or if you bring a few people over to the house, we see sometimes that too as well. But again, if you just, because I won a case actually with a personal protection order, I was defending them, and I remember they only had one incident that actually happened, and it was a huge incident. It was a assault and battery. It was a criminal charge. However, we won the motion to terminate the PPO because of the fact is it was only one incident. And he's like, "What do you mean? I have to have two or more incidences?" And we're like, "Yes, you do. That's the law." So I always like to let people know that, because I don't want you filing something. Then if you really do have another incident that happens, then they may not go and grant your personal protection order later on.
So, what do you suggest for individuals who are trying to obtain one of these personal protection orders?
I would suggest that you, first of all, contact an attorney. Myself, our firm takes care of a lot of these. But again, if you don't have enough money to represent yourself, you can go down to the court. Now, the legal advocates, they can't give you legal advice because they're not attorneys. However, they can guide you on what forms to use, whether it be a non-domestic or a domestic form. And I suggest that you always make sure that you have all your information with you. And another thing is, don't fill it out at court. I've seen too many times that people fill these things out, they handwrite it, and what happens is they forget an incident or they forget a time period. You want to be specific because you want this to be granted, because it's only going to help you in the future.
Excellent. And what if you're on the other end of this and you get served with a protection order?
Great question, because a lot of times these get used sometimes as an abuse mechanism. And I've seen that several times, and it's sad because you cannot get attorney fees for those, because if you ask for attorney fees, they're not going to give you, the judge is not going to give attorney fees, because there's law that says that we don't want to re-victimize a victim. We want people actually to come to court to file these personal protection orders. We don't want to defray them, or make it look like if I file this PPO, I might have to pay attorney fees later. So it's kind of a twofold situation there. But as soon as you get served, you need to go and review that petition, first of all, because it's already on lien, and that can jeopardize you having guns. It can have infringe upon you going to different places, your work, sometimes the place that the other individual works. So you want to make sure that you get into our office and we go through all the incidences and the allegations. And then what we do is we come up with a game plan. I go and file a motion. I draft it up myself. We go into court. We actually do what is called a mini trial in my terms, but we place on like a mini trial. We have our witnesses lined up, might even have to have police officers there, and we ask questions and get the testimony. And hopefully at the end of the day, we will have the PPO terminated.
That would be the best outcome, especially if it's a lot of made up stuff.
Yes, and thank the Lord, I've actually won several of these this year. I think I won all of them, so that's quite a great record that we've had.
Yes, it is. That is awesome. So I've heard some stuff in the news about something referred to as a red flag law. First, what is this, and does Michigan have it?
So absolutely, Michigan does have what is called a red flag law. It's all over the news, and what we actually call it is called Extreme Protection Act. So we call it EPA. The Extreme Protection Act, I actually testified at the Senate against this bill, this legislation, because as an attorney, I will not recommend this. And the reason why is because we already have a personal protection order. It basically does the same thing. We also have petitions to place people in inpatient if they have a mental disability, mental health disability. So there was no reason to have this, because what it does is it actually infringes on your constitutional rights of your Second Amendment, your Fourth Amendment, your Fifth Amendment, your Sixth Amendment, and also your 14th Amendment, which is your due process, because it's actually an ex parte motion that you're getting. So somebody can come in and take your guns.
Why would someone want to look for this kind of an order? It seems like a really extreme assault against someone else, a legal assault, if you will, as opposed to a physical one.
What I predicted, and this is what I've actually stated to several people. I go out and speak on this quite a bit in public gatherings, public settings, and I explain what the law is. The legislation is very lengthy, so I'm giving the short term of it because there's lots of nuances. And the definitions of, the significant other, if whether you dated or not. So people use this as a political motive to go after someone. So it's kind of like legal warfare. That's what I call it. And I saw this actually right when we were having this testimony as in a PPO, a personal protection order. We had, I represented a lady that was actually the head of the Republican Party over in a county. And it was a Democratic woman who just despised all Republicans. I mean, it's okay to disagree on politics and things of that nature, but you don't have to go and take people's livelihoods away, their guns, their friends and their families. And, it was a very huge, because this woman actually went to lots of parent teacher conferences and was part of the PTO meetings, and she was not able to go to the school because this woman was there. So
yeah,
we had probably over 1,000 documents and exhibits, and they filed it in a different county, not even where the person lived, and it didn't even happen. The incident didn't even actually happen in that county. They went to an area where their political side is very well known. So actually, they went venue shopping. And so that's what is very fearful of me, or myself as a lawyer, because not only does it take your constitutional rights away, it's an unbalanced warfare. And also, it's a crime to go and falsely state something. But do you know how many people actually get charged for perjury for testifying wrong on the stand?
I'm going to say near zero.
You're absolutely correct. But lately I've been trying to get transcripts of different ones lately, because not that I'm a prosecutor, excuse me, but I just want to make sure that, I don't like lying because when you take that oath, that's a very serious oath. You're going to tell the whole truth and nothing but the truth. So I hope I answered your question. I may have gotten a little off there.
Yeah, I can see that you're very passionate about this issue and why you feel like it's a significant problem in not just the legal system, but society.
It is.
So what do you suggest that someone does to kind of prevent or preempt the use of these kinds of extreme protection acts or PPOs being used against you without cause?
Well, that is a wonderful question, because as I stated earlier, not only did I testify at the Senate against this bill, but I also, talk about this publicly, and I've been trying to teach people this. First of all, just be nice and kind. I mean, that's the old-fashioned way of saying things on Facebook. If somebody calls you a name, you don't have to call that person a name back. Don't put your guns. If you have guns in your household, don't post pictures of your guns on Facebook. That's kind of not very smart. It's not smart of an individual to do that, because one, you're going to have a home invasion, but two, you're also going to have somebody try to use this against you. And three, I would also suggest that you come see me at our office. I've done a lot of cease and desist letters. I'm actually called the C&D lady in one of the counties, because of the fact is that it explains, it's a very lengthy letter, it explains the constitutional rights, the violations, and it puts them on notice that their behavior is extreme and that is not warranted and it's not wanted by my client. So therefore, if they do that one more time, one more incident, my client can actually go get a personal protection order prior to that. So it's like a defense mechanism, kind of preemptively taking care of that situation so they don't go for that Extreme Protection Act. And I also state this, please, people, do not go and draft up your own cease and desist letter. You're not an attorney, number one, and number two, you don't know what you're indicating, and they're not going to take it seriously because we have it actually personally served on the individual, and that puts a little bit more teeth into it.
Yeah, it's much more sobering when you have that deputy or that process server sitting on your doorstep and going, here you go.
Oh, absolutely. Absolutely.
So thank you for sharing your wisdom today, Kristina.
Oh, my pleasure.
And thank you for joining us. If you are feeling like a protective order might be for you, or perhaps you've had one levied against you that has no merit, or you just want to understand your rights, Kristina Lyke is the voice you want in your corner. Visit likelaw.com to schedule a consultation and learn more about how she defends freedom, faith, and your future. You don't have to fight alone. Stand up, speak out, and protect what matters most with Kristina Lyke.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.